Welcome back to For the Defense. My name is David Oscar Markus, and I have a real treat for you on the podcast today. We have Matt Menchel, one of the great trial lawyers, and also a close friend. He's going to be discussing the Raoul Weil case. Weil was a Swiss banker at UBS, and Matt represented him in federal court in Fort Lauderdale. Matt and I go way back. We tried a case in Fort Lauderdale, one of my first cases when I was a federal public defender and he was an assistant United States attorney. That was in the Fort Lauderdale courthouse before Judge Gonzalez. And I learned a lot from Matt during that trial, and we became close friends from trying cases against each other. Now he's one of the great criminal defense lawyers. You're going to hear us discuss tactics such as how long should a cross-examine go on for? How do you decide whether to put on a case or not? Whether you should follow Oliver Irvin Younger's commandments. Both Matt and I, when a jury has been out, we've both sought help from a higher power. You're going to hear us discuss stories like that. It's a really fun episode, and I'm really proud of it. I hope you enjoy it as much as I do. Matt Menchel and For the Defense next. Welcome back to For the Defense. We've got the wonderful Matt Menchel here on the show this morning, and Matt is a very close friend, but more importantly for the show, one of the greatest trial lawyers. We've had cases against each other when he was a prosecutor, when he was a federal prosecutor down here in the Southern District of Florida. Before that, he was a state prosecutor in New York, and now he's one of the finest white-collar criminal defense lawyers. If I had a family member in trouble, Matt would be the guy I'd call. So welcome to the show, Matt.
Thank you, and thank you for that very kind introduction.
So we're going to be talking about a really fascinating white-collar case. In a lot of ways, a complicated case, but in a lot of ways, a pretty simple case as well. Your client's name was Raoul Weil. Can you tell us a little about him and who he is and the charges against him?
Sure. So Raoul Weil was a banker at UBS, the largest bank in Switzerland, the third largest bank in the world. And at the time of his indictment in 2008, he was the number 3 person at UBS and widely understood to be the next in line to become the CEO of the entire bank. He was in charge of the private wealth division, which was the largest private wealth division in the world with $2.6 trillion of assets under management. So he was a very important figure at the bank, a very beloved figure, I might add as well, very highly regarded and respected by virtually everybody at the bank up until the time of his indictment, which effectively ended his career from that point forward.
Pretty crazy how much money was involved, both that he, was sort of tied to in the bank itself. And the bank, I guess, settled for some huge amount of money, right?
So the bank entered into a deferred prosecution agreement with the DOJ and settled for $780 million. This was all based on a whistleblower complaint filed by a UBS banker who happened to be an American named Bradley Birkenfeld, who blew the whistle on UBS, and he got $104 million of that $780 million, plus 40 months in jail for his own participation in the scheme. But it actually, the $780 million seemed paltry because later Credit Suisse settled under similar circumstances for $2.6 billion.
Crazy. And they say crime doesn't pay, but I guess that the whistleblower got over 100 million. When that got released, my friends and I used to talk about whether 40 months was how much money you would have to take to do 40 months. Certainly 100 million, everybody agreed they would do, which we don't need to talk about him, but just crazy numbers.
Yeah. And to be clear, the amount of money that was at issue was not the amount of money of the assets under management. We were talking about a very, very small percentage, actually less than 1% of the private wealth division, which concerned U.S. persons or U.S. clients of the bank who had bank accounts in Switzerland at UBS who were not reporting their income tax to the U.S. IRS.
Well, tell us. So tell us about that. What was Weil actually charged with?
So he was charged with a single count of conspiracy to defraud the United States, specifically the IRS, in a conspiracy to assist U.S. taxpayers who had accounts at UBS in hiding their assets such that they would not have to pay income tax on it. That was the gravamen of the charge.
And at the time, I mean, this was what, around 2014-ish, the trial?
Well, he was indicted in 2008. The Swiss do not extradite their citizens for tax-related offenses. And so he remained in Switzerland for most of that time until he took a trip in 2013 to Bologna, Italy, with his wife. And he was arrested at the hotel in Bologna, Italy at 1:30 in the morning and brought to a very dangerous maximum security prison in Italy outside of Bologna, where he was there for 2 months until he was extradited to the U.S. Actually, he waived extradition.
Did he know about the charges when he was traveling, or he wasn't aware of them?
He was aware that he was under indictment. The indictment, by the way, was what forced UBS to settle because, just as a quick side note on that, UBS wanted to go through the treaty negotiation process. There was a treaty set up between the U.S. and the Swiss, and they wanted to go through the treaty process to try to resolve the disputes they were having with the U.S. government. And the U.S. government was having none of it. They indicted Raoul Weil as basically a very clear message: if you don't start doing what we want you to do, which in part, by the way, was to disclose a number of U.S. clients who had these accounts, we're going to take hostages. And Weil was the first one. So the indictment was unsealed in 2008. UBS settled within months of that indictment.
Right.
And I was not his lawyer at the time, but he was under the impression, obviously mistakenly, that he could travel outside of Switzerland. He just couldn't come to the United States. So he was aware of the charges, but unaware that he would be arrested in Italy when he went there.
So he gets arrested in Italy, and you say he goes to a very dangerous prison. There's a crazy story about what happens in that prison. Can you tell us about that?
Yeah. So this prison was built actually to house terrorists, and it wound up housing at the time he was there not only terrorists but murderers, members of the Sicilian mafia, really the baddest of the bad. And what had been reported in the Italian press at the time of his apprehension was that he had stolen $200 million. Mm-hmm. In fact, the allegation was he had assisted U.S. taxpayers in not declaring $200 million worth of income tax. But that had been misreported in the Italian press. And so very early on, he was taken into a room with another prisoner who was claiming to befriend him, and he put a knife right up to his face and demanded to know where the $200 million was.
Holy cow.
Weil had to explain he doesn't have $200 million. And by the way, Swiss bankers, while they're not poor by any stretch, they don't make the kind of what I'm going to call Jamie Dimon money that we're used to hearing about in the U.S. Nothing even close to that. It's a very different system. But luckily for Raoul, he wound up getting housed in a cell with two brothers who were members of the Sicilian mafia. They took a liking to him, and he was basically protected for the rest of the time he was there during those 2 months.
It's like a movie.
Yeah, it was. And knowing him, he's one of the most unflappable men I've ever met in my life. And he probably took this as just another experience. He also began at that time to start writing down what was happening to him, really just to keep a record that he thought he would be sharing one day with his family members and close friends. And that later turned into a best-selling book that was a bestseller in Switzerland about his entire ordeal from the arrest onward.
We need to get that translated into English.
Yeah, unfortunately it's in German, and I know I'm mentioned in it. He kindly said that to me, but I can't make heads or tails out of what he's saying.
So he had a group from Fresh Fields as his lawyers, and then you get brought on only shortly before the trial. Tell us about that.
Yeah, so Fresh Fields, which is a very highly regarded, what's called magic circle firm in the United Kingdom, one of the top law firms in the UK and throughout Europe. And he was very capably represented by Fresh Fields, particularly Aaron Marcoux, who was lead counsel for them, and Kim Zelnick, who was another partner working with Aaron, as well as a whole team of associates who were really top-notch folks. But the case was indicted in the Southern District of Florida. It was pending before Judge Kahn in Fort Lauderdale, who we both know. And Aaron hired me because he said he wanted, quote, more firepower to bring on board. And I was more than happy to join the team. So I don't remember exactly when I came on, but probably 5 or 6 months before the start of the trial, I started getting onboarded onto the case. You mentioned Judge Kahn, who, so people know, he's this Southern gentleman who is a judge in Fort Lauderdale, one of the best judges we have. He's a big Alabama fan. He's a character, and I'm interested to hear. We'll get into it how he was during the trial. Yeah, he was. I mean, it was my first experience with him. I don't even think I might have appeared in court maybe once before him as an AUSA, but I'm not even sure that that's true. I don't remember. But this was really my first experience with him, and it was really one of the more pleasurable trial experiences I've had. Of course, when you win, you always say that.
Yeah.
But it really was. It wasn't one of those things where, okay, looking back on it, I'm happy with the outcome and therefore happy with the court. No, he was a very fair-minded guy from the beginning and really gave us some very important rulings that shaped the outcome of the case.
Well, I've lost a trial in front of Judge Kahn and walked out of there liking the guy. And I said, "What just happened? I lost, and I still like the guy," which is, like you say, it rarely happens.
Yeah. No, he was terrific. He's, very big on time. Doesn't like to waste a minute of the jury's time, which is fine. So he doesn't like sidebars. We had them, and every time I would ask for a sidebar, he would reluctantly give it, but it was grudging. But that's only because he wanted to move the case along for the benefit of the jury.
Right.
I wound up having lunch with him after the trial was over, some weeks later, and he asked me to speak to his clerks about the case, which I was happy to do.
So nice.
Yeah, he was a total gentleman throughout.
So let's talk a little about some of the pretrial rulings in the case, because I think they're important. And, a lot of times the pretrial rulings get overlooked because we're talking about trial, but these were important. The first one had to deal with a jury instruction that you were able to get. Typically, jury instructions are dealt with at the last minute, but in this case, you guys dealt with it pretrial. Tell us about that.
Yeah, and in order for me to explain that, I don't want to bore the listeners in too much detail, but I think it's important to understand what this case was basically about.
Yes.
Swiss bank secrecy in Switzerland has been the law, as far as I know, since the beginning of Swiss banking. And not surprisingly, many people have used it not only in the U.S., but throughout the world as a way of hiding assets, not only perhaps from their own family members, but from their own governments who are the taxing authorities.
Right.
In 2000, the IRS entered into an agreement with a number of Swiss banks called the Qualified Intermediary Agreement, or the QI agreement, as it was referred to throughout the trial. Mm-hmm. This agreement mostly dealt with giving incentives to Swiss banks, giving tax breaks to Swiss banks involving foreign nationals having U.S. securities. That was not our case. But there was a small provision or part of this very complex agreement that dealt with U.S. persons or U.S. clients who had Swiss accounts. And basically, up until that point, the IRS was aware that there were many U.S. clients who were not reporting their income tax.
They had the accounts to hide them. They had the accounts to hide them.
Yeah. About 20,000 accounts, according to the U.S. government. So as part of this QI agreement, a compromise was reached between the IRS, the U.S. IRS, and the Swiss banks, which was, look, if you have U.S. clients, okay, they have to do one of three. There are one of three things you can do if they have U.S. securities, okay? If they want to hold U.S. securities in a Swiss bank, that's fine, but you have to insist that they fill out a W-9. And then by filling out a Form W-9 and signing it, then obviously the bank would issue a 1099 and the taxing authorities, the IRS, would be aware of the income. That was option one. Option two was, and this was the compromise position, if U.S. persons or U.S. clients still want to have a Swiss bank account, they can do so, and they can keep it secret and undeclared, but they have to divest themselves of all U.S. securities. They can only have foreign securities or cash. They can't have U.S. securities. And if they do that, the U.S. persons are still on the hook to pay whatever income tax they should be paying. But the bank had no obligation to do anything. There wasn't a W-9 that they were required to have signed, or a 1099 that had to be issued, nothing. If the U.S. client refused to either sign a W-9 or divest itself of its U.S. holdings, then the bank was required to do what was called a forced sale, meaning they had to liquidate the account, okay, and a very large withholding tax, about 30%, would be withheld and paid to the U.S. government.
Okay.
Very few clients chose that option. Those that did probably was because they couldn't get in touch with those people, but the vast majority either went with options one or two.
So they reached this agreement, the QI agreement. And the bottom line is you guys use that agreement in your defense and in this pretrial motion to get this jury instruction.
Yes, because what the government was arguing was that it was still a crime for UBS to have U.S. clients who had secret accounts. And that simply was not true. There was a contract between the IRS, and in this case, UBS, but any bank that signed this agreement, which said you can have a U.S. client that has a secret Swiss account so long as they don't have U.S. securities. And the government simply either didn't understand that or refused to accept that that was clearly the contract. So we got an instruction which said that they were allowed to do that. And therefore, there was no fraud, because our argument was you can't defraud the IRS out of something that they agreed to do and agreed to allow. And that was the gravamen of our defense for a lot of the case.
But I find it fascinating that you were able to litigate that jury instruction issue pre-trial, because as I said, most of the time that gets, a judge will say, well, let's hear the evidence. I'll wait till the end. How did you get it teed up and get that jury instruction?
Yeah, and again, credit to Freshfields, because I think it was either Kim Zelnick or Aaron Marcoux who argued this motion. I don't believe I did. But we felt it was important that the jury be instructed as part of the preliminary instructions, so they understood the framework, okay, of what this case was about. That was our view. And by the way, my memory is the government fought tooth and nail to keep this
out. Of course.
So, our argument was that you needed to understand this in order to understand the evidence as it was unfolding before it was unfolding, because it was so important. And, Judge Kahn, being the great jurist that he is, agreed. He did say to me later, he said, I had no idea the impact that instruction would have on this case. It really was the difference between winning and losing, because getting the instruction from the court that this was absolutely allowable, okay, really put the lie to a majority of the government's case. There were other aspects of the case that we had to deal with, but a big part of their case was it was inherently unlawful just for the bank to allow undeclared accounts to continue to exist. And that simply was not true.
Another huge pretrial ruling you got, Matt, and I found this fascinating, is there was this report issued that your client had not done anything wrong by another investigative agency overseas. And, you and I talked about this, like neither of us would ever think that's admissible. And yet a young lawyer litigated it and was able to convince the judge to get it in.
Yeah, that all credit to Kim Zelnick, who I think the lesson on this one, David, is sometimes being too experienced can be a bad thing, because you close your eyes to possibilities that may exist that you don't think exist. So in this case, what you're referring to is the Swiss Banking Authority, in the wake of the Birkenfeld whistleblower complaint, launched its own investigation into the allegations. And we haven't talked about this yet, but one of the mainstays of the allegations, which was true, okay, was that after the QI agreement, some of the Swiss bankers in the North American desk, the desk dealing with U.S. clients, were helping Americans hide their assets by setting up sham or fake foundations or trusts in other names so that they could get around the QI agreement by having U.S. securities, but the U.S. securities would be in the name of a Liechtenstein or Bahamian trust or foundation, and therefore hiding the identity to the U.S. authorities. That absolutely happened. Had nothing to do with Raoul Weil. We'll talk about that in a minute. But the Swiss Banking Authority, called FINMA, did an 8-month, very comprehensive investigation, found that those things did occur, but they occurred at the lowest levels, only up to the mid-level of the bank, and that the higher level banking supervisors, like Raoul Weil, who was mentioned by name, were not told about this, and in fact knew nothing of it, and would not have tolerated it, because they even noted that Weil was a total zero tolerance guy when it came to compliance. He wanted total compliance enforced, and they exonerated him by name in the report. So Kim Zelnick so this would be a great report to get before the jury. We have the Swiss Banking Authority exonerating our client on the very charges that the U.S. government is bringing. She wrote this motion and she said, I want you to look at it. And I kept saying, there's no way that report is coming in. There's just no way, right? There's no way a judge is going to let another tribunal's finding of innocence or exoneration come in our case. And she said, well, you just read it. And she kept pestering me to read this. And I kept putting it aside. And finally, she got very angry. And I said, okay, fine, I'll read it. And so I read the report. And my colleague at the time, Adriana Riviere, I said, I'm reading this thing and this can't be right. She cited a bunch of cases. And I told Adriana, you got to pull these cases for me. And I read the cases and I'm like, oh my God, she's right. This is admissible under the public records exception under the hearsay rule, as long as you can show that the report was inherently reliable. So we filed this motion in limine before Judge Kahn. And I recall him saying something very similar when he took the bench. He said, I got to tell you, when I read this, I said, no way this is coming in. And then I read the law and I realized you were right. So he let it in. But at the same time, the government was seeking to get in the deferred prosecution agreement, sort of arguing what's good for the goose is good for the gander. I saw them as two entirely different things. One was an investigative report. The other was a settlement, not involving our client. And Judge Kahn said, well, I'm not going to let it in unless they open the door. Mm-hmm. I didn't know what that meant. All I knew was that it scared me. So we got the report in, but we made very light use of it. And I really didn't focus on it too much until the end of the trial during the closing arguments.
It's interesting because a report like that, you and I would think would have enormous impact, but I think you guys did some focus groups and those focus groups weren't all that impressed with the report, which I find interesting.
Yeah, we definitely did a jury exercise with a great jury consultant, Dorr, and a woman named Julie Blackman, who was fabulous, who's since retired. But my memory of it is that it really didn't have that much sway. And when you think about it a little bit more deeply than I guess I thought of originally, it's that, well, they're hearing the facts themselves, right? So it's not unusual that the jurors would say, well, that's fine that they made that decision, but we're going to make our own decision. And I think it didn't hurt to get it in, obviously. It was very helpful. And it wound up being a very important point of cross-examination with one of the government's cooperators, which I can talk about in a minute.
Yeah, we'll get there in a minute. But one thing I want to talk about while we're here is, there's been a lot of debate on the podcast about whether these jury exercises are useful or not. Some lawyers love them, some lawyers hate them. What's your view on doing these jury exercises, these focus groups before trial?
Yeah, I definitely don't hate them. I use them. I think they're a tool. I don't know that they're necessarily predictive and should be used as outcome predictors, because it's a very compressed thing, right? And sometimes, right, something that may have taken 15 or 20 minutes in a focus group could be 2 days of testimony. And so in a focus group, you may wrongly conclude, well, the jury didn't seem all that interested in that, but that's because it was minimized just by the compression of time. So I think you have to take them with a grain of salt. But to me, it's more information. And I think more information is better than less. And to the extent that it helps inform what is resonating and what isn't, I think it's valuable. Of course, you grew up in the state attorney's office in New York, where, forget about focus groups, you get handed the file sometimes the day before trial. I mean, let's talk about that for a second. I've been handed files walking to the courtroom for trial when I was in the attorney's office. Not often, but that did happen to me. Right. I mean, wasn't that a wonderful time, though, to be able to jump into a trial like that without the 6 months or years of preparation? Yeah, look, I think it's good and bad, and I'll tell you why. I think it is great to learn how to question on your feet, how to think on your feet quickly, and have to respond to things that you might not have been fully prepared for because you simply didn't have the luxury of time. The problem is I've sometimes seen state prosecutors, when they transition into more complicated cases, let's say they become federal prosecutors, they don't know what to do with the time, right? They're not used to having this preparatory time. And you have to learn, obviously, that it's not ideal to try a case that way, but it is helpful because you learn certain tricks. You learn how to phrase certain questions because when you're not sure what the answers might be in a way that won't hurt you, for example. Right. But it was that time in my life was enormously helpful because the sheer volume of trials I was getting. This was the 1980s and 1990s in New York City at a time when drugs were rampant, crack epidemic had happened, heroin was making a comeback, and I was a drug prosecutor for most of that time, and it was literally like picking, fruit from a tree. I was trying as many cases as I wanted, and I liken it to when you learn how to ski, they take you to a green hill, right, the least steep hill, and you can practice rudimentary things like how to turn, and eventually how to become a parallel skier and how to do a proper stop, and later you can even practice things like skiing backwards. Not something I ever actually did, but I looked at it the same way, right? The fact patterns were relatively simple. Not that the cases were necessarily easy to win, but the fact patterns were simple. And it allowed me to develop skills because I didn't have to spend so much time understanding the case. The case was simple, right? And so I could really focus on technique, on how to cross, for example, and how to develop better ways of opening, things like that.
You probably saw some great New York defense lawyers who probably, some of them didn't even get recognition, just coming in trying those drug cases and doing great.
Yeah, there were a number of really great lawyers back then. There was a law firm called Goldstein and Weinstein, or Weinstein and Goldstein, who were two guys out of the Bronx who did an incredible number of drug cases, and they were formidable. I tried cases against both of them, a number of cases against both of them, and I had nothing but respect for them, and I learned from them. They taught me things.
Of course. And, you know, I've told stories on this podcast. When I was a brand new lawyer, I tried cases against you and learned a lot of tricks about, you know, one thing is trying to undermine the credibility of your opponent. I think that's a critical part of the trial. The jury's going to look to which lawyer they trust more. And it's something I learned from you in one of my first trials. I use it to this day, trying to, during trial, undermine the credibility of the other lawyer.
You know, one of the most amazing experiences I ever had was my very first jury trial. And what happened there was, back in those days, once the jury got the case, they were sequestered. Okay. So if the jury didn't reach a verdict, let's say they got the case at 1 o'clock in the afternoon and they didn't reach a verdict, they went to a hotel with court security officers watching them. And
Wow.
then they would resume again in court the next day. And if they didn't reach a verdict, they'd go back to the hotel. As a result of that was since disbanded. I think the economics of that were insane. So as a result of that, you would often get verdicts late at night. So my first verdict came at 10 o'clock at night. And it was a drug case. It was a simple buy and bust, but not an easy case. The man who was convicted had neither drugs nor any of the marked money on him, right? So not an easy case, a pure identification case. And after the jury was released, we set a date for the sentencing. And I walked out, and imagine this is 10 o'clock at night. The courthouse is empty.
Right.
And about 6 of the 12 jurors are standing by the elevator bank, clearly waiting for me. And I get into the elevator with them, and we were trained in the Manhattan DA's office, never speak to a convicting jury.
Okay.
You can only hear things you don't necessarily want to know, and then they have to report, right?
Okay.
Better, you've won, leave. So I'm looking down at my shoes, and I can feel that all the other 6 jurors are sort of looking at me. And finally, one of them says to me, "Mr. Menchel, can we ask you a question?" By the way, I'm 25 years old at this time, right? I'm a young prosecutor. And I don't want to be impolite. And so I think for a moment and I say, "Yes, but I don't want to know anything about your deliberative process. Don't tell me anything about deliberations." And they said, no, it's not that. And the question that they asked was, he was guilty, right? Now, they had just voted guilty, right?
Oh,
and that was an eye-opening experience for me, because what it told me was they wanted validation from me that they had just done the right thing. And then the question is why, right? And I think the answer is because they understand intuitively, if not consciously, that the lawyers know more about the truth of the case, the facts of the case, than they're getting. And the reason why they know that is every time a question is asked and then there's an objection and the judge sustains it, that's a piece of data that's been kept from them, right? Every time there's a sidebar, we're talking about stuff they're not allowed to hear. Every time they're sitting in the back room for an hour, they come back into the room and the judge says, "I'm sorry, we had to talk about matters outside of your hearing. Sorry to delay you," right? That's more stuff. And in fact, in that exact example, they were right. I knew things. For example, I knew that was the 3rd or 4th time the man had committed that offense. That wasn't admitted during the trial.
Right.
I knew that the co-defendant who had pled guilty had implicated him, but we had cut a deal that we wouldn't call him at the trial. Right. So there were things like that. And so you're right. I think the jury understands that both lawyers know more than they're getting. And then the question is, which of the 2 lawyers can they trust is the one that's going to give them the truth? And so I think you're right. I think a trial is largely about, to the extent you can, jealously guarding your credibility and undermining the credibility of your adversary.
Fascinating. And so let's go back to the Weil case in trial. You're headed into this trial. Does the government make plea offers? Do they try to get a deal done, or is this a definite trial?
Oh, they made multiple plea offers. I don't remember. There were three. I don't remember what the initial one was, but 3 days before the trial, they had offered him, they had offered Raoul a year and a day, which would also include the 2 months he had done in the Italian prison. He was not interested. I don't think there was any plea offer they would have made him that would have, maybe he would have taken a plea had they offered him nothing just to get it over with. But he's a very principled man, and he really didn't think he did anything wrong. I frankly didn't think he did anything wrong, and he wanted his day.
Those are the best clients, because even times when clients believe they've done nothing wrong, sometimes they take a deal. And I think in this investigation, there were people like that.
There was another Swiss banker at UBS who was my client prior to Raoul Weil, lower level banker who had been arrested coming into the U.S. based on information that yet another cooperator had provided. And he was here under house arrest in the U.S. in Miami for at least a year, might have been a year and a half, with 2 young children in Switzerland with his wife, who occasionally would come. They didn't have a lot of money. They would come maybe once or twice a year to see their father. And at the end of the day, the same prosecutor, by the way, same lead prosecutor, wound up offering him 33 days, time served, which was the amount of time it took to transport him when he was arrested in New York and brought to Miami. So confronted with that, he said, let me make sure I understand the situation. I can hold fast to my position. I'll get indicted. It'll take at least another year, maybe longer, before I go to trial. You're telling me I have a good chance of winning, but you can't guarantee it. I'm facing 5 years, or I can plead guilty to the 33 days that I've already served and be on the next plane to Zurich. And I couldn't argue with the logic of that. But it irked me to no end. And the fact that they offered him 33 days tells you everything you need to know about their own belief in their case.
Of course. And that's why, another guest we had on the show, Jed Rakoff, who you tried a case in front of recently, wrote that article, Why Innocent People Plead Guilty. That's a perfect example. Everybody would take that deal. It'd be foolish not to, even if you're 100% convinced of your innocence. It's just too risky to go to a trial when they're saying you take time served and go home.
And by the way, we got all the discovery that we would have gotten for him in the Weil case. And once we saw the discovery, it only confirmed what we knew, which was they had no case against this particular banker. But rather than let it go, in order to save face, they made him a deal. They made him an offer he couldn't refuse.
Right. So let's talk about some of the cross-examination, because I think this is where, you were amazing. And, I know you talk about the pretrial litigation as critical to winning the case, but to me, the crosses won the case. The first one is this guy. Is it Schumacher or Shoemaker? How do you say his name?
Hans-Rudi Schumacher.
Schumacher was one of the cooperating witnesses, and I guess testified under this what's called a queen for a day letter. And so people know what that is. Typically, people testify with a deal in place. They've either pled guilty, they've gotten immunity, they have some sort of deal before they testify. This witness testified under a very sort of informal queen for a day. It's a letter saying, we won't use what you say against you, but that's really there's not much teeth to it.
Right. And let me just set the stage for this. 2 months before trial, the government had told us that they had one Swiss banker who was going to cooperate and testify against Raoul Weil. And that was a gentleman named Martin Lichty, who was below Raoul Weil in the chain of command, and who really was the one pointing the finger at Raoul Weil that even got him indicted in the first place. My view is that the government realized how vulnerable he was. And so they got desperate and started cutting deals, so that by the time we got to trial, there were 5 Swiss bankers testifying against Raoul Weil. Schumacher, who had been indicted for a number of years, had been trying for well over a year and a half to get a deal with the DOJ, and they weren't interested. And now that Weil was pushing forward for trial, literally, they rushed it so fast that they couldn't get him to plead and enter into a cooperation agreement, which is the norm. They had him testify under a queen for a day letter. They just expanded the date an extra couple of days. He was
jumping on the bus, Matt, a moving bus this time.
Yeah, it was amazing. I was able to bring out on cross that essentially what that agreement says is we are evaluating you, and whether or not we're going to decide that your cooperation is worthy, whether or not your statements are worthy of cooperation. So I was able to have some fun with Cross on the idea that as you're sitting here right now, those folks over at that table are, quote, evaluating you to decide whether they're going to accept you as a cooperator while you're testifying under oath. And the other point that we were able to make was, and by the way, you're accepting responsibility for nothing. Because right now, everything you're saying can't be used against you under this Queen for a Day agreement. In your case, with some limited exceptions, as you know, but for the most part, he was able to say whatever he wanted without fear that it was going to be introduced against him in his own trial. So he said all these things, with at the time he was saying it, with no ramifications that it was going to hurt him.
Amazing.
It was unbelievable.
So as you're getting ready for this cross, I mean, things are happening quickly. It's the last minute. I imagine your days from the DA's office come into play because you don't have too much time to get ready for the Schumacher cross. We
didn't have too much time, but again, and I made a joke. I remember after the cross was over saying it takes a village to do a cross, because with Adriana and then also with the incredible Freshfields team, we had a very robust cross. And there were some really dramatic moments. And in fact, not only the Freshfields folks, but Raoul Weil's wife also played a very important feature in this. And if you'll allow me to tell that little vignette, I think it's interesting. So one of the things that Schumacher was going to testify, Schumacher was the sort of immediate supervisor of the North American desk. And they had clearly gotten legal advice after the QI agreement that they could not advise U.S. clients on setting up structures, period, full stop. That would have been a violation of the QI. You cannot advise or insist in any way. And no sooner does Schumacher get that legal advice that he then takes all the senior people off of it and emails down below him and says, we have to find an innovative solution to this problem, meaning we have to basically ignore it and figure out a way around it. So we can continue to help our U.S. clients set up sham structures and do what they have to do. Schumacher eventually leaves the bank upon the enforcement of the QI to go to a bank that is not a QI bank so that he can continue to help U.S. taxpayers avoid taxes.
Right. And
so what he wants to do is solicit all of his clients to come with him, because he's basically saying, look, UBS is no longer going to be in the business of helping you hide assets. You should come with me. And in particular, he testified that one U.S. person, I'm going to refer to him by his initials, even though it was public record, JR, a man who had many, many millions of dollars under management, I think 75 million, if I'm remembering correctly. Schumacher went to see him shortly after he resigned from the bank and said, look, UBS is not going to keep your money safe anymore. You need to come with me. And according to this, by the way, this is a conversation that happened 12 years before Schumacher's testifying to it.
Oh, my God.
And according to Schumacher, JR, the U.S. person, the U.S. client, said, I met with Raoul Weil and another banker, and they told me, quote, my money is safe at UBS, meaning they're going to continue to help me hide my assets. If the jury believed that testimony alone, Weil was guilty of conspiracy.
Right,
that fight. Okay. So prior to the trial, we didn't even have the name of the U.S. Client. I think it had been redacted. I think it was later disclosed as a co-conspirator statement, but we didn't have it initially. But there were emails describing who he was, that he was a New Yorker, that he visited Basel at least once a year, that he had a business that was going to be taken over by his children soon. So Susan Weil, right, world's greatest detective with no formal training, put her mind to work and said, if he's going to Basel, he's only going there for one of two reasons. They have two fairs there. They have the art show and they have the jewelry and watch show. But he said he was in a business that was on the lower end of business. Well, there's no lower end art business. There's a lower end watch business. So she perceived he was now a watch dealer selling low end watches, living in Manhattan, of an older age because his children were going to be taking over the business. And using that and reading through a bunch of the Swiss files, you should understand, the banking client files are only numbered. They have no names on them. They're just numbered files.
Huh.
She was able to give the folks at Freshfields those search parameters, and they located the file, the JR file of this particular client. And the Swiss, very much like the Germans, are notorious record keepers. So every contact that any banker ever had with a client was notated in detail, when it was, what was done, so on. And so sure enough, there was a meeting that took place after Schumacher resigned, but before Schumacher met with JR, where he was encouraged to stay. But it wasn't with Raoul Weil. it was with the government's main cooperator, Martin Lichty, who they were going to call at the end of their case.
It's like a Perry Mason moment. It's a Perry Mason moment.
We were able to prove, because of Susan's work, beyond any question, Raoul Weil's name wasn't even in the file. He never interacted with this guy once. Okay. It was just another fiction that the government didn't bother to look at because it was there. You just had to find the file. It took a lot of detective work to get. And once we found it, by the way, the government stipulated that's his file, right? So we got it in, and we were able to show that Schumacher's either recollection was mistaken at best, or at worst, he was inserting Weil's name where it was really Lichty, one or the other.
I wonder how his testimony was evaluated after he got caught with his pants down.
It got worse from there because he also, we had a great moment also where the one part of the case, as I mentioned earlier, that absolutely was happening was the setting up of these sham structures. And we were able to show Schumacher admitted it multiple times that Raoul Weil wasn't even in charge of the North American desk at that time. He was running Asia and Europe. He had nothing to do with the North American desk and the U.S. clients. And we got him to admit repeatedly that Raoul Weil had absolutely nothing to do with this and had no knowledge of the use of sham structures. So that
I saw that part of the transcript where you ask him for the names of people who were involved, and he starts giving them, and then he says, you don't expect me to remember every name, and you say, no. Like, that's good enough, but no Weil, and that is a risky question to ask about, pointing to your client and asking about your client, and he gave it to you.
Yeah, I walked over. I felt he was already locked in because I got him to admit that it was him and everybody below, and obviously Raoul Weil was many, many levels above.
Right.
So at that point, I wanted to cap the point, right? So I literally walked over. I didn't plan this. I didn't script it in my head. It was a moment that just came to me, and I walked over, went right over to Weil, pointed at him and said, "This man, Raoul Weil, had nothing to do with this, right?" And he said, "That's true." And Aaron told me later on that when I was asking that question, I don't know if we're allowed to curse on these podcasts,
yeah.
But he said that he was shitting a brick. But I didn't feel it was a risky question at that point because he had been locked in. There was no way he could change it at that point.
But Matt, and you and I have talked about trial strategy before. A lot of lawyers would have just waited till closing and argued it. And you and I both believe like that's not the way to do it. You have to take advantage of those dramatic moments. The jury's waiting. Like if you wait till closing, it's too late. You have to take advantage and cap off the point, or it's not as dramatic or it's not as important as it could be.
I completely agree. Look, obviously there are certain things you can only go so far on the cross, and you can't dip your toe a millimeter further, or you're going to get burned. But I think the difference is skilled cross-examiners know when they can and when they can't, right? And he had already been locked in that the only people who knew were the people below him. Ergo, it couldn't have been Weil, who was many levels above him. So why not make the point explicit? Why not make it clear? Why not make it personal to Raoul Weil? And I agree with you. I think, when you have someone locked in, you have to have the confidence to know that you're right. And I knew he was going to go with me. I mean, he already was. What was he going to say? Now that you're asking me the third time? No, I told him he'd already been locked into it. So I wasn't worried about that. And he was really destroyed as a witness as a result.
So that was one of the first witnesses. Was it the first witness or? I
think they called the records custodian, but he was the first substantive witness. Yes.
So the trial starts off really strong, and then their main cooperator you also decimate. Is his name Lichty? Is that how you pronounce it?
Yes, Martin Lichty. Yeah.
So the cross there I think goes for 3 days, which I've never done a cross for 3 days. That sounds exhausting to me.
It was exhausting. Look, I know you and I are both students of trial advocacy. We're junkies. We're nerds about it. And I know, we all know Irving Younger's 10 commandments of cross-examination. And one of them is be short.
Right.
Be brief. I have tremendous respect for the late, great Irving Younger. But I don't understand that advice. I don't mean that you should be long. Okay, I think the answer is that the cross should be as long as it needs to be to make the points you want to make. And if that's 20 minutes, great. But if it takes 3 days, it takes 3 days. And, look, I put a witness on direct once for 6 days. And I was prosecuted. How long should the cross be? 20 minutes? Right. I mean, it needs to be as long as it needs to be to cover the ground that needs to be covered. And so Lichty testified to a 10-year period of time. And he testified for probably about a day and a half. I crossed him for twice as long, but that's because they were not really relying on any of the documents. They were just relying on his testimony and very few of the documents. And what we were able to do through the documents was to show that almost everything Lichty said was false. Lichty, for example, claimed that he was interesting because on the one hand, he didn't want to accept responsibility for knowing any wrongdoing or doing any wrongdoing. By the way, he was given full immunity, so he had no reason to not just tell the truth, but his own vanity, which is what I think prevented that. And on the other hand, he said, I was running to Raoul Weil to let him know about all these problems. It made no sense. It was inherently contradictory. But one of the things he kept saying was that I went to Raoul Weil and I told him about this and I told him about that in these one-on-one sessions that he called bilaterals, meaning it was just be me and him in a room, and we would do this every day. So we had bilaterals almost every day was his testimony. There was a couple problems with that. One was that he himself then testified he was traveling 2 to 3 weeks out of every month, and Weil was also traveling as frequently. So the amount of time that the two men were actually in Switzerland at the same time was very, very limited. Two, almost everything he claimed that he said in a bilateral, we were able to prove with an email. He said just the opposite to him.
Right.
So, for example, he'd said, I went running with Raoul Weil saying we have compliance problems. We'd show an email which said, you have nothing to worry about. We're in full compliance. And when I would confront him with that document, he would say, that's not how I remember it, as if somehow his lack of recollection was going to make the document magically disappear. One of the more dramatic moments was Schumacher. As I mentioned earlier, Schumacher resigned to go to another bank to lure away U.S. clients. So Lichty testified that as soon as he handed in his resignation, as soon as Schumacher handed in his resignation, Lichty said he didn't even wait for a bilateral. He went running with resignation in hand into Weil's office to tell him Schumacher has resigned and we have to do what we can to retain the U.S. clients. There was only one problem with that testimony. Raoul Weil wasn't his boss at the time he went running to him. Raoul Weil was still in Asia. Okay, and wouldn't be promoted into the position that would make him his boss until 4 or 5 months later. Okay, so it would have made no sense. He would have went running to Raoul Weil with resignation in hand when Raoul Weil wasn't his report, and Raoul Weil had nothing to do with the desk. So when he got caught in that lie, he said, well, I knew he was going to be my boss. And so rather than run to my current boss, I ran to who I knew would be my future boss. Except we then showed that it wasn't even announced that Raoul Weil was going to be the future boss until 2 weeks before he became the future boss, which was, again, many months after the resignation of Lichty. So, time and time again, we were able to show through preparation, and again, hats off to Freshfields that did the bulk of this work, that almost everything he said was not true. And we were able to prove it with the documents.
One of the pieces of advice, Matt, that I like to give to lawyers is, try not to be Albert Krieger, try not to be Roy Black, try not to be Matt Menchel. You got to be you. And I know, you're a New Yorker and you can raise your voice during cross and that's who you are. And I think you got some bad advice during this cross.
Well, it wasn't that particular moment when he lied about going to Weil and then lied that he knew Weil was going to be his boss, which was why he then claimed he ran to him. I got overly excited and I started to raise my voice. And I think Lichty said, you don't need to raise your voice. And I think I said, I do need to raise my voice. And at the end, Judge Kahn, when we took a break, said, now, there were a couple of questions toward the end of that examination that had there been a objection, I would have sustained those. And so, Aaron and the other members of the team perceived that Judge Kahn was unhappy with me. And by the way, I thought he might have been as well. So I dialed it down in the afternoon. And one of the things that we did in this trial, and it's only the second time it was the first time I'd ever done it, was we used a shadow juror. And what that is we had another person that Doar had selected. I think it was like an intern from Doar who sat in the courtroom, but only when the jury sat. So, and we had no interaction with this guy. So he only saw and heard what the jury saw and heard, nothing more, nothing less. And every night he would write reports of his impressions of the day. And that night he wrote a report and he said something like, the morning was great. Menchel was on fire. And then he said, in the afternoon, what happened? Where was the mustard? Those were his exact words. And so that's just one guy's perception, but his perception was that it was appropriate passion and voice raising. And I later spoke to Judge Kahn about that, and I asked him, "Were you unhappy?" He goes, "No, it was fine. I was just letting them know that they could stand up for themselves a little bit because the government had gotten very quiet during this cross." So I went back to more of the passion that I was bringing naturally. This wasn't forced. I was genuinely impassioned by the fact that I felt the government had put a man on trial that was not guilty, and they knew it.
Yeah,
that was my firm belief, and so that was what was coming through during the cross.
I like using the mustard, so I think you got to use it when you have it. I also love hearing stories about how clients sort of perceive it and are dealing with it. And your client was so, as you say, unflappable. I think he would tell us the story. He was giving you like little chocolates during this cross.
Well, I have a penchant for chocolates, as one can tell just by looking at me. Raoul knew that, and so each morning during this cross did last 3 days. He would put a little Swiss chocolate on the table where I would begin my examination. And I'd have that for my little morning fuel, if you will. And then when the trial was over, he sent me a whole case of them.
I love it. I love it.
Good guy. But to your point about this, we'll talk about it in a second. We didn't put on a defense, but the man had so much dignity and poise and grace that Judge Kahn, when the trial was over, said to me that he had just observing him, he picked up on all of that, and he never saw a man compose himself. This is what Judge Kahn said, with such dignity and grace, while his finger was being pointed by 5 different bankers at various points for things that they said he did that we knew he didn't.
And the U.S. government. And the U.S. government pointing at him.
And the U.S. government. And I thought it was amazing that Judge Kahn, who never heard Raoul Weil speak, as far as I know, was able to pick up on that perception, because he was exactly right. The man was incredibly dignified throughout the entire process.
You raise that there was no defense put on. To me, this is the most difficult decision that we make as defense lawyers, because, we don't have to put on a case. Everybody knows that. But I think, generally jurors want to hear from the defense, want to hear, especially from the client, but also from witnesses. And a lot of times we put on no defense. Tell us about that decision in this case and how you came to it.
Yeah. And I should start by saying that we had developed a robust defense. Again, mostly Freshfields had done this work. I had done a little of it, but we had, by my recollection, 12 witnesses lined up to testify in favor of Raoul Weil, which was more witnesses than the government put on in their case in direct. A number of them were Swiss nationals who the government would not agree to give safe passage to. So we had filed a motion in advance and got the court to allow them to testify via video in London. They couldn't do it in Switzerland because the Swiss rules are different. They don't swear witnesses in Switzerland, for example, and they don't, and witnesses are allowed to actually take their testimony back, which I found fascinating. So we had lined up a very robust defense, but we felt the case went incredibly well. We got lucky because we had a number of days. I think the government finished their case, I think, on a Wednesday or a Thursday. And we asked the judge to give us some time so we could fly over the witnesses. And Judge Kahn, being again, that's his thing, his time, reluctantly agreed to break early in that week. And that gave us about 4 days to really hash through, did we want to do this? And there was very robust debate amongst the defense team. And I remember at one point, Aaron Markus, understandably thought, hey, we got great witnesses. Why aren't we putting these people on? And he said to me, what are you afraid of? And I said, Aaron, let me ask you something. Do you think the government thought their case went in as expected? And he paused and said, no. I said, that's what I'm afraid of, right? That the same thing can happen to us. This is an inherently unpredictable process, right? Trials are living things that mutate once born. Once one of my colleagues once said to me, in directions and in ways you can't imagine. And so I felt we had done enough to at least get a hung jury. My colleague Adriana was firmly in the camp. We had won this case. It was over. I wasn't prepared to go that far yet, but I definitely felt very good that we had literally demolished all of their cooperators on the critical points. And so after much hand-wringing, I got everyone to agree. I didn't make them say, this is a group decision, because if we lost, obviously you would be wondering forever. You left 12 people, not including the client, who were ready and willing to come and testify on his behalf. When we went back in on the following Monday to announce we weren't putting on a case, I remember Judge Kahn was a little perturbed because he felt he'd given us a break to line people up. I thought he might be happy that, well, we're not putting on any case, but and I think he was, but I also think he felt like we could have moved the case along faster, but he was fine about it. And Aaron, I believe, was the one who stood up and in front of the jury said, we're resting, meaning we're not putting on a defense. And I remember one of the jurors, like it was yesterday, I remember where he was sitting. He turned, he looked back behind to another juror, and he gave a face and a hand gesture like, I told you so.
Right.
And that gave me great comfort. I know we often can't read the jury right. We're often wrong. Jurors are nodding with us. We think they're in our camp. We find out they're the leader against us later. But this was a very obvious cue that he was saying, and I told you so, look. And I read that as they're not going to put on a defense because they don't need to. So that decision turned out to be the right decision.
But before we get to the closings and the verdict, and this case got a lot of press, especially international press, a lot. And there were reporters in the courtroom during the government's directs, during the government's opening. They'd race out and write about it, but they wouldn't stick around for the crosses and the defense point of view. And so a lot of people following the case thought, this guy's sunk. He's in big trouble. I mean, it's one thing that really bothers me about media coverage. How do you deal with that?
Well, let me explain what happened, because it was really shocking. And I wasn't paying attention to the media. They were behind me. And you're right. By the way, this wasn't a New York Post or obviously a sensationalized case, but it was carried by the financial press very heavily, by Bloomberg and Reuters and German press and Swiss press and French, all financial type of media. And there was a large group of them behind me, but I didn't notice. And when Schumacher first testified, he said a lot of very, sexy things. He talked about Swiss bankers traveling with diamonds and toothpaste tubes, none of which had anything to do with Raoul Weil, but nonetheless was sexy stuff in the case. And when I got up to do the cross, I didn't notice, but people told me the entire press corps got up and walked out.
It's crazy.
And during my cross of Schumacher, one of them sent me an email and said, Mr. Menchel, can you let me know when you're going to be done with Mr. Schumacher's cross? I want to know when to return the courtroom. So I liken this to watching a football game where the only time you're watching the game is when the team you like has possession of the ball. And you think it's a blowout because they've just scored 5 touchdowns. But of course, you're only watching it when they have the ball. And the other team got 10 touchdowns, and it was actually a blowout in the other direction. You just weren't watching it.
Right.
So I heard, I wasn't following the media. I don't read media while I'm trying a case. I don't know. There's no value to it as far as I'm concerned. So I didn't read it. And I still have never read it, frankly, the media that was reported at the time. But I later was told that the media said we were getting killed. And I find it very frustrating. And, one of my pet peeves, David, is when you watch these cable news networks, right? And they always say on a case, they always have some, talking head legal expert who says, juries are notoriously unpredictable. Look, I've been doing this 36 years. If I felt that trying a case was the equivalent of closing my eyes and throwing a dart at a board, and wherever it landed, if it was that arbitrary, I would have quit a long time ago. I haven't always agreed with the jury verdict, but I can honestly say I've never been surprised by one. I don't know if you feel the same way, but I've never sat there and go, how did that happen?
Fascinating.
I'm sure there are moments, I'm sure there are verdicts like that, but they're very few and far between.
Yeah.
And the reason why it seems unpredictable is because if you're reporting with a bias and a slant, and then the verdict goes in the other direction because you weren't accurately reporting the case, it seems like it was a wild and crazy verdict.
Right.
I mean,
they typically only say it's wild and crazy when it goes the defense way, honestly.
Right. Exactly.
Yeah.
Right. Exactly. And look, I mean, this case, Judge, we did a Rule 29 motion, right? A motion to dismiss the case before it went to the jury. Judge Kahn reserved. That didn't mean anything to me. I've had other judges that do it as a matter of convenience. They'll reserve and then they'll issue either a written or oral decision later, denying it. Right. I've never won one. But he later told me that it was only the second time in his 30 years on the bench at that point. He'd been a state judge before a federal judge. that he had reserved on a Rule 29. And he was fully intending on setting the verdict aside if the jury had not rendered the verdict of not guilty, which they did. But the verdict came back in under an hour. In fact, we were still, you know how it is, David, when there were hundreds of exhibits introduced. You have
don't get to the verdict yet. We got to build up to the verdict, Matt. Let's go closing first, and then we'll get to the verdict. So let me ask you about closing first. So when you were a DA, obviously you would close with a legal pad, and then as an AUSA, maybe you'd type up a closing or have some notes. Now, when you do closings, I imagine you have slides and decks and blow-ups. How important is that in a closing? I know you did it in this case as well.
I use a PowerPoint presentation in every closing I give now. And if I have the benefit of a Doar or Dubin Consulting, another great jury consulting firm, Josh Dubin and his folks I've worked with, they're great. Both firms are great at graphics design. And what will happen is during the course of the trial, they're endlessly making slides of snippets of testimony, of key documents with blowups on them, of key jury instructions and the like. Yeah, I find them really helpful because when the slide comes up, I just know what I'm going to say. I'm not competing against the slide. I'm using the slide in conjunction with my speaking. So if it's up there, I'm usually reading right from it, and sometimes, depending upon how I'm physically situated, pointing to it and going over word by word with it. But I think giving them both a visual, I think we're visual learners, most of us anyway. And so I think to have the slide with the actual testimony is usually important. I don't want them to be relying just on my paraphrasing of what the witness said. I want to use, if I can, the actual transcript. I think it's particularly important, by the way, in our district, David, because we don't have readback here, where the jurors are read back transcript. In New York, it was done as a matter of course. So this will be the only time they'll probably get to actually see snippets of the transcript. And I think it's very, very important that you use the actual words and the testimony that you got, not a paraphrase.
Critical. All right, let's get to the verdict. So the jury goes out. I mean, we've talked about this on the podcast many times with lots of lawyers. Literally the worst feeling you can have as a lawyer while the jury's out.
Jury's out, and they got the case late. By my recollection, they got the case around sometime after 3:30. We did not expect we were going to have a verdict. In the meantime, there were hundreds of exhibits that had to be gone over with the government because you have to have agreement that, yes, that came in. No, that was only marked as for identification, but not admitted. And there were hundreds of them. So it was going to take probably several hours. I wasn't the one doing it. If you know the Fort Lauderdale courthouse, it's a very weird courthouse. There's like a outdoor deck.
Right.
I was outside on the deck, just, chilling out. And at about 4:30, we got the court security officer came out and said, the judge wants to see you. I presumed he wanted to talk about next day. You know how it is. Where are you going to be? Who's going to be accessible? How far from the courthouse are you allowed to be before the verdict comes in? The logistics of what you have to do while the jury is out. Instead, he passed the note around, which said in all caps, "We have a verdict," 2 exclamation points. In fact, I have it embossed. Freshfields made a little trial block with the verdict sheet on it.
Oh, I love that. That's great.
See, right?
Yeah, that's cool.
At that point we knew. So they came in. I think Aaron wanted us all to, maintain our calm. That was sort of his instruction to us. And as soon as the verdict was read, we exploded. We just erupted. I remember banging my hand on the table, not realizing that the reverberation of that going through the microphone was going to be unbelievably loud. And it was. And Judge Kahn, to his credit, just let us have that moment. Raoul's wife was there. She was hugging him over the railing. Kim Zelnick, who had been working on this case since 2008, broke down. I started tearing up, to be honest. And when the jury was excused, Raoul just said, in his typical fashion, "So where are we going to dinner?"
That's awesome.
Those were the first words that he uttered. And then he was out the next day and back home, where he was really welcomed, almost given it like a hero's welcome in Switzerland, because he was the first Swiss banker to actually fight the government and not just accept whatever they were willing to give him.
Where did you go to dinner?
We went to some restaurant on A1A. I don't remember. It was in Hollywood, on A1A somewhere, but I don't remember exactly.
Matt, you mentioned, you teared up, the emotions there. I don't think people who are non-lawyers or even non-criminal defense lawyers realize how much we put into these trials, how much, not just, time, but our beings, our emotion, our you put everything you have into it. You're sort of putting yourself out there to the jury, and you have a man's life in your hands.
Yeah, I got to tell you, as you know, David, I was a prosecutor for 20 years before I became a defense attorney. And I put just as much effort and work into being a prosecutor, but it's not the same. The emotional commitment and the feeling of that responsibility, it weighed very heavily in that trial. I would be lying if I said to you that I did not seek help from a higher power during that trial.
Yeah, we all do. Even though I don't believe I always do. It's really crazy.
Me too. I'm not sure I believe either, but I believe in those moments.
I'll tell you. I haven't told the story, but Margot and I, during the Gillum trial, there was a church right across the street from the courthouse, and when the jury went out, they were out for a while, and one day while they were out, we walked and sat in the church. I'm Jewish and I don't even believe, and I was sitting in the church praying.
I've done that as well. I've gone into a church, not that trial, but there was another trial where a colleague of mine took me into a church, and hey, when in Rome, whatever works. But it was an enormous relief because it's one thing, as you know, look, we represent our clients to the best of our ability, whether they did it or not. But in this case, I really feel it was an extraordinary injustice had been done to this man. I said it in closing. I said, look, his life is already ruined. Okay. It's been destroyed. His career's over. He'll never have the same career. Let's not assassinate him further with this verdict, That's
good. I'm going to steal that.
Actually, what I stole, since you're talking about stealing, was that came from the Welch McCarthy hearings, where he said, Senator, let us not assassinate this lad further. You have done enough. And I used it by saying, let's not assassinate this man further. Our government has done enough. And actually, Khan told me that was a moment that also resonated with him. He hadn't really thought about the implications until I mentioned them. And look, there was no evidence about what I said. I just said it, right? But it was kind of obvious, right? They knew from the testimony he hadn't been in the bank for years. His career was destroyed. It really caused him to level set his life after that. He works now a couple of days during a week as a consultant. It's been a very different existence for him. But, he had the courage and the integrity to see it through. And as a result of him, other bankers went to trial subsequently, who were also acquitted. Some were also convicted, but there were those who were also acquitted. He was really the first one to go up against the government and say, I think you're wrong, and I'm going to fight for it.
The other thing we always talk about, Matt, when we see each other is how many trials you have in you, because these trials take years off your life, and you only have, you and I agree on this. You only have so many trials in you before it's too much.
I always think of The Princess Bride, that movie where the main hero is being tortured with this machine. And when he gets done, I think it's Christopher Guest. I don't remember who the bad guy is, but he says something like, I've just taken a year of your life. Right. And that's how it feels. It feels like every trial is a sucking of a certain amount of time from you. And I do think it's finite to some degree. And I know with me, if I start to feel that my skills are diminishing to a point where I'm not doing it at a level that I want to do it, then I'll know it's time to stop. If nothing else, that'll be the barometer for me.
Well, they're certainly not diminishing. One of the things that I want to do before I finish up is try a case with you. So we got to find one to do this. This was a wonderful interview, and I just want to thank you for taking the time, Matt. I'm
honored to be on the podcast both with you and also with seeing the names of the other guests that you have. That you would be kind enough to allow me to be on. It was a real pleasure and a real treat, and thank you so much.
It's always such a pleasure to discuss trial tactics with a master like Matt Menchel. Thank you, Matt, for being on the show. As good a trial tactician and trial lawyer as Menchel is, he messed up the impressions of Judge Kahn. So sorry to Judge Kahn if you're listening about those impressions. I know that Southern accent that Menchel did, being from New York, did not do you justice. So sorry about that. But Judge Kahn is the best, and we need to get Judge Kahn on the show. We have a lot of great episodes coming up in the next couple of weeks. I'm really excited about it. Big thank you for listening. If you could comment, review the podcast, spread the word, I would really appreciate it. That's how we get the word out. Thank you for listening. I'm excited about the podcast. Thank you.